You're about to hear how a corner piece of American liberty, the writ of habeas corpus, is being weaponized to fast-track mass deportations. In early May 2025, White House Deputy Chief of Staff Stephen Miller stood before reporters and declared, "The privilege of the writ of habeas corpus can be suspended in a time of invasion. That's an option we're actively looking at." He framed it as a necessary emergency fix to speed up deportations, all while painting Venezuelan migrants as invaders under an old wartime statute. Here's what he didn't tell you. The Constitution's suspension clause in Article 1, Section 9 is crystal clear. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Only Congress, not the President, can invoke that extraordinary power, and historically it has happened precisely 4 times. Lincoln during the Civil War, Ulysses S. Grant fighting the Ku Klux Klan, Taft in the Philippines after the Spanish-American War, and FDR after Pearl Harbor. Never once did any president act unilaterally. Never once did courts allow it without legislative approval. Miller's gambit rests on 2 dubious premises. First, that the U.S. is suffering an invasion by a Venezuelan gang called Tren de Aragua, which no credible intelligence agency or international body recognizes as an invading army. Second, that contorting the Alien Enemies Act of 1798 into a deportation warrant would somehow outrank the foundational right to challenge unlawful detention. Last March, Trump invoked the Alien Enemies Act in Presidential Proclamation 10903, falsely claiming Venezuela was at war with the U.S. He attempted to deport hundreds of Venezuelans under this 18th century law designed for bona fide wartime enemies. Within hours, the ACLU and Democracy Forward filed JGG v. Trump, and a D.C. federal judge issued a temporary restraining order. Even conservative jurists chastised the administration for reaching back to a law premised on an invasion that literally didn't exist. This isn't just legal hair-splitting. Habeas corpus is your safeguard against indefinite detention, the guarantee that no one, citizen or immigrant, can be locked away without judicial review. Think of it as the safety latch on executive power. Strip it away, and you hand the presidency the ability to incarcerate anyone indefinitely, without ever telling them why, without ever letting a judge see the evidence. Trump himself, in a taped interview with Kristen Welker, admitted he wasn't sure due process applied to deportations. I don't know if that's the Fifth Amendment privilege. It might say that, but if you're talking about that, then we'd have to have 1 million or 2 million or 3 million trials. In other words, he viewed trials as a barrier to his mass deportation goal, not a constitutional right. That mindset laid the groundwork for Miller's push. Since taking office, Trump has sought ever more aggressive shortcuts. Family separations, zero-tolerance prosecution quotas, travel bans on majority Muslim countries, and now this unprecedented bid to suspend habeas corpus. Each time, courts have slapped him down. In JGG v. Trump, a 3-judge D.C. panel ruled that the Alien Enemies Act cannot override due process. In Obrego Garcia, the Supreme Court unanimously blocked removal orders where immigrants had no fair hearing. Last month, in a 7-2 decision, the court reaffirmed that summary removals without judicial oversight violate the suspension clause. Yet Miller's answer is to double down. When in doubt, call it an invasion. Bypass the courts and deport first. Ask questions later. Behind the headlines is a simple truth. This push isn't about law or security. It's about power. It's about dismantling the checks and balances that limit the presidency. Trump's warlike rhetoric, an invasion of migrants, a battle for America's soul, serves as cover for policies that would strip fundamental rights from millions. Today it's Venezuelans. Tomorrow it could be protesters, journalists, or any group the administration labels an enemy. You deserve to know how close we are to a constitutional crisis. When the executive branch treats habeas corpus like an optional clause, it doesn't just threaten migrants. It endangers every American's right to due process. In the next section, we'll dig into the court battles that nearly stopped this assault in its tracks, and why they may not be enough. Federal judges moved swiftly to slam the brakes on the administration's scheme. On March 15, 2025, mere hours after President Trump signed Proclamation 19903, invoking the Alien Enemies Act against Venezuelan migrants, a 3-judge panel in Washington, D.C., granted a temporary restraining order. The suit, filed by the ACLU and Democracy Forward in JGG v. Trump, argued that the act had no application in this situation and violated statutory immigration procedures that expressly provide the sole and exclusive procedure for removal, procedures mandating notice and an opportunity to be heard. Less than 3 weeks later, on April 3rd, Judge James Boasberg publicly threatened contempt proceedings against White House officials who refused to comply with his orders. Boasberg warned that if the administration failed to identify the officials responsible for carrying out unlawful deportations under the Alien Enemies Act, he would appoint special counsel to pursue contempt charges. His blunt message underscored the judiciary's unwillingness to tolerate executive overreach. In Texas, Judge David Hittner in the Southern District delivered an even sharper rebuke. On April 24th, he issued a permanent injunction blocking any deportations under the Alien Enemies Act within his jurisdiction, finding the administration's reliance on an 18th century wartime statute to expel migrants baseless and at odds with the Fifth Amendment's guarantee of due process. Simultaneously, Judge Catherine Hellerstein in New York echoed the same conclusion. Neither Venezuelan refugees nor alleged Tren de Aragua members amount to an invasion, and summary deportations without evidentiary hearings flagrantly violate constitutional mandates. Amid these clashes over deportations, another case exposed the administration's procedural chaos. Kilmar Armando Abrego Garcia, a Maryland resident ordered withheld from removal in 2019, was inexplicably flown to a Salvadoran prison and held for nearly a month without any judicial warrant. On April 4, 2025, Judge Paula Sheenis in Maryland ruled that his transfer shocks the conscience and ordered the administration to return him by April 7th, citing the egregious error and the inhumane conditions at El Salvador's CICOT prison. The government's appeal prompted Chief Justice John Roberts to stay the deadline, yet the broader directive to facilitate Abrego Garcia's return remained intact. On April 10th, the Supreme Court unanimously affirmed Judge Sheenis' order. In a 9-0 decision, the justices refused to block the lower court's mandate to ensure Abrego Garcia's release, while cautioning that directives must respect the deference owed to the executive branch in the conduct of foreign affairs. The ruling underscored that even in matters touching diplomacy and national security, due process cannot be brushed aside. The crescendo came on May 16, 2025, when the Supreme Court delivered another blow to the administration's deportation gambit. In AARP Trump, the court held that the Alien Enemies Act cannot be wielded as a fast-track deportation tool. An unsigned per curiam opinion emphasized migrants' right to notice and a hearing before being expelled, and sent the case back to the Fifth Circuit for further review. Justices Alito and Thomas dissented, but the majority made clear that even centuries-old statutory powers must bow to constitutional due process guarantees. These judicial interventions reveal two unavoidable truths. First, the administration's claim of an invasion by Venezuelan migrants was a fiction unrecognized by any credible intelligence or legal authority. Second, the courts remain the last and most formidable bulwark against unilateral power grabs. Despite threats of contempt and emergency proclamations, the judiciary has repeatedly reaffirmed that no president, past or present, can suspend fundamental rights without Congress, let alone bypass the rule of law on a mere executive whim. The backlash didn't stop at the courthouse doors. Within days of the Supreme Court's latest rebuke, on May 16, 2025, Republican moderates and staunch conservatives united to block Trump's signature deportation and tax cut bill in the House Ways and Means Committee. That measure would have extended his 2017 tax cuts, funded mass deportations under the Alien Enemies Act, and eliminated overtime and tip taxes. Yet enough Freedom Caucus members deemed it too soft on immigration to pass even their own muster. On Capitol Hill, Representative Jim Himes of Connecticut demanded answers from the Office of the Director of National Intelligence. He pressed Tulsi Gabbard to reveal why two senior analysts who debunked the administration's claims of a Venezuelan invasion by Tren de Aragua were abruptly ousted. Himes warned that purging analysts for political convenience would shatter confidence in U.S. intelligence and risk unraveling the very fabric of policy grounded in facts, not fear. Meanwhile, leading human rights organizations launched coordinated campaigns targeting both Congress and the White House. Human Rights Watch called on lawmakers to repeal the Alien Enemies Act altogether, pointing out that the law's framers feared exactly this kind of unchecked executive power. They reminded Washington that in 1798, legislators warned it would turn judges into mere enforcers of presidential will, an experiment on the American mind that Thomas Jefferson refused to renew in peacetime. The National Immigration Law Center rippled through social media with a 5-point framework for reform. They urged protests outside congressional offices, demanded hearings on the act's history, and mobilized pro-immigrant coalitions to lobby key senators. Their message was relentless: suspending habeas corpus for any group, even non-citizens, challenges the rule of law and endangers every American's liberty. Senator Alex Padilla and a bipartisan group of colleagues sent a letter to the White House, branding Trump's proclamation illegal and unprecedented. Their statement stressed that invoking the Alien Enemies Act does not make Americans safer. It endangers all of us by removing due process protections and ignoring the plain text of the statute. They demanded immediate data on how many deportees had been transferred, their conditions in foreign prisons, and the legal basis for each removal order. Public opinion polls taken in the aftermath show a nation unnerved. A Quinnipiac survey found 62% of voters oppose suspending habeas corpus for any immigrant group, even those accused of serious crimes, and 54% say Congress should investigate the administration for overreach. Strikingly, support for strict immigration enforcement plummeted 8 points among independent voters once they learned about the due process violations. State attorneys general from California, New York, Illinois, and Washington filed a multi-state lawsuit seeking to halt any deportations under the Alien Enemies Act. They argued that no state constitutional provision allows local law enforcement or National Guard units to enforce this federal proclamation, and that deploying troops on the border would violate the Posse Comitatus Act. Their brief warns of militarized checkpoints and the risk of civil rights abuses if executive claims go unchecked. At the same time, foreign governments began to weigh in. Canada's Minister of Immigration publicly queried whether Ottawa should tighten its own asylum screenings to forestall a similar U.S. invasion panic. The European Parliament held an emergency session condemning the use of wartime statutes to expel civilians, invoking memories of World War II internment. Even regional trading partners raised concerns about potential U.S. sanctions or asset freezes against Venezuelan nationals, warning that business ties could fray under this legal ambiguity. Inside the White House, though, the mood remained defiant. Vice President J.D. Vance took to social media in mid-April, suggesting that due process was negotiable if the goal was at least a few million deportations per year, an admission that sent shockwaves through both parties. Senior staffers privately fretted that every new legal skirmish further eroded Trump's credibility on national security and economic stewardship. As Capitol Hill prepares for summer hearings, one question looms. Can Congress reclaim its constitutional duty to suspend habeas corpus, or will it continue to cede power to the executive branch? The fate of due process and of America's tradition of checks and balances hangs in the balance. Federal judges remain sharply divided. On May 13th, a federal judge in Pennsylvania became the first to greenlight Trump's use of the Alien Enemies Act, ruling that the 1798 statute could apply to deport alleged Tren de Aragua members as enemy aliens without prior hearings. Yet 3 days later, the Supreme Court once again extended its block on mass removals, faulting the administration for issuing bare-bones deportation notices and insisting judicial review must be available before any expulsion under the wartime law. This split underscores that while some lower court judges may tolerate the administration's aggressive tactics, the High Court continues to serve as the ultimate check on due process. Legislative momentum stalled as Trump's broader fiscal immigration package collapsed under intra-party revolt. On May 16th, conservatives in the House Budget Committee blocked the One Big Beautiful Bill, which would have paired extended tax cuts with funding for mass deportations, citing insufficient spending cuts to Medicaid and green energy credits. Moderates and swing district Republicans balked at linking tax relief to sweeping immigration enforcement, leaving Speaker Mike Johnson unable to muster the slim majority needed to advance even a procedural vote. With Congress in recess until Memorial Day, no clear path exists for legislators to authorize the suspension clause or rein in executive overreach anytime soon. Across the globe and in civil rights quarters, alarm bells are ringing. Human Rights Watch has formally called on Congress to repeal the Alien Enemies Act, reminding lawmakers that its framers feared its potential for unchecked executive power and that Jefferson himself viewed it as an experiment on the American mind. In Ottawa, Canada's immigration minister privately pledged tougher asylum screenings after Trump's threats of tariffs leveraged migration fears, an overt display of how U.S. rhetoric can reshape allied policies. Even the European Parliament has circulated non-binding resolutions condemning any use of wartime statutes to expel civilians, likening it to mid-century internments that Europe still warns against. With the summer session looming, attention turns to whether Congress will reclaim its constitutional role. Senate Majority Whip John Barrasso publicly downplayed prospects for any executive suspension of habeas corpus, asserting on NBC that the president respects the Supreme Court and intends to follow the law. Yet a bipartisan letter drafted by Senator Peter Welch urges the Senate Judiciary Committee to convene immediate hearings on the administration's infringement of due process, warning that silence risks eroding our constitutional order. Meanwhile, legal scholars caution that any future bid to suspend the writ will land back before an already strained Supreme Court, where a narrow majority has so far thwarted every shortcut to mass deportation. The coming weeks will determine if America's checks and balances hold, or if the Constitution itself becomes collateral damage.